Good day and hello to everyone who's joining us for our webinar. I want to thank you for coming here. My name is Barry Penner. I am the Managing Director of the Canadian International Internet Dispute Resolution Centre, or CIIDRC for short, and also Managing Director of the parent organization, the Vancouver International Arbitration Centre. The reason you're logging in today, though, is not to hear so much from me, but rather from our distinguished presenter, the Honourable Neil Brown, QC, who is a Queen's Counsel in Australia after having had a distinguished career in government and also in law. He's a qualified arbitrator and a mediator practicing in international and domestic matters in the commercial, communication, intellectual property, and government fields. He's a leading arbitrator and advisor in internet domain names and disputes, and was a minister in the federal government in Australia and an adjunct professor of law at Murdoch University in Western Australia. And I also want to just note that for our organization, the Canadian International Internet Dispute Resolution Centre, Neil was an early supporter and provided us with plenty of practical advice as we launched in 2019. So as noted, the CIIDRC is a wholly owned subsidiary of the Vancouver International Arbitration Centre, but we operate globally. We have a global reach. We are one of 6 providers for UDRP cases authorized by ICANN, and one of only 2 in the Western Hemisphere. We are the newest kid on the block, but we've been at it for a couple of years now. And Mr. Brown has offered to provide us a walkthrough of some of the interesting cases that have been dealt with during that time. So without much further ado, I'd like to turn it over to the Honourable Neil Brown. Neil?
Thank you very much, Barry, and hello to everyone. It's a great pleasure to be here today at 9 a.m., which it is in Melbourne, Australia, a very respectable time, and to spend a bit of time with you on some of the developments that have taken place in the internet domain name arbitration world under the auspices of your organization, the Canadian International Internet Dispute Resolution Centre. By way of introduction, I thought I might explain to you how this presentation came about. I got to thinking a few weeks ago about the work that the CIIDRC has been doing, and I wondered whether the decisions that had been handed down followed any trends. Were there any themes emerging? Were the decisions worthwhile? Did they stand up? Are they useful to people practicing in this field? And to have a general bird's eye look at what the CIIDRC had been doing since it became accredited by ICANN, the non-profit company that more or less runs the internet from Los Angeles. And I suppose some of my conclusions I've really set out on this first slide. I hasten to add, we all run a risk of being power pointed out, and I don't want to inflict that on you. So I've tried to keep my comments on the slides to a minimum and just make a few, I hope, worthwhile points. And the first general point that could be made from that slide is that you have now had 2 years experience, and I think it's true to say that there's quite an impressive array of decisions that have been made by arbitrators appointed by CIDRC in those 2 years. In fact, there are 42 decisions, or about 42 decisions as of today, by CIDRC panelists on most of the major issues that arise in this field of arbitration. And that really is a good achievement. So I think that's the first point I would like to make. You can be very proud of the achievements of the centre in this comparatively short time. And although you may well be and are the new kid on the block, as Barry described it, and I've described it myself previously, the new kid on the block is a happy and healthy, virile participant in what is going on in this field. It therefore is worthwhile, I think, for us to bring ourselves up to date on some of these decisions and where they are going and how they can be used usefully for practitioners in this field, no matter which side of the fence they may be on, whether they are claimants or defendants. I thought I should also say that although decisions, of course, are important, and I wouldn't be talking about them today if they were not important, that they are not precedents in the strict legal sense of the word, simply because they are not given in a hierarchy of courts where decisions can be binding on lower courts. But they are nevertheless, although they're not precedents, they're quite valuable decisions because they really are illustrations of what panels arbitrating these cases have decided to do in previous cases. And therefore, they may well be a guide to the way in which panelists will decide similar issues in the future. So trends emerge from these decisions, and they show not only how decisions have been made, but how they are likely or possibly going to be made in the future on similar facts in the future, in cases that arise in the future. So they don't bind anyone at all, but they are, of course, persuasive, to use that other word. Now, what are these decisions that we're having a look at today? Well, they are decisions of panelists appointed by CIDRC under the Uniform Domain Name Dispute Resolution Policy and its rules. And you will find all of the decisions to read at your pleasure and your leisure on the website of CIDRC, which is set out there on the screen. It's important to understand, of course, and my guess would be that no one in this audience needs to have it repeated, so I don't want to teach you to suck eggs, but it's important to realize that what we're talking about today is the Uniform Domain Name Dispute Resolution Policy that applies to all of the big league of domain names, the .coms, the .nets, and so on and so forth, and also to the now well over 100 new domain areas like .club, .melbourne, .sydney, and a lot which have an individual company's name. So they are decisions which are drawn from a wide field and have a wide application. They are not decisions concerning your own unique Canadian.ca cases, which I know are very popular and very popular in Canada on very good grounds. It's a very good system, and the policy itself, the .ca policy, is in fact a very good policy, which has some good points in it, which are actually not in the UDRP, the Universal Domain Name Dispute Resolution Policy. But what we are dealing with today, we have looked at the uniquely Canadian.ca cases in the past, and no doubt we'll be looking at them in the future as well, and you will be writing about them and talking about them and thinking about them, and so will I, because I have done a few cases for you which are .ca cases. That has its own role, and it's an important role, of course, but what we are doing today is to see which of the decisions in the big league of the .coms and the new range of top-level domains like .club, etc., how they have been going when they have been emanating from CIDRC and from panelists appointed by CIDRC. Just as another point to get your mind working, a question arises whether these decisions, some of which are three-person panels, whether they are more significant decisions than the run-of-the-mill one-person panels. All arbitrators, including me, most of their work is concerned with one-person panels for the simple reason that a lot of these cases are not defended, and therefore the reality is that the dispute is arbitrated by a one-person panel. But there are three-person panels, which we can go into detail at some stage, if you like, on how a three-person panel is appointed. And I think it's fair to say, well, look, a one-person panel decision is interesting, but a three-person panel is conceivably three times as good, especially if it's a unanimous decision. You might say, well, perhaps we should give more credence to a decision which comes from a three-person panel, especially if it's unanimous, than we would give to a one-person panel decision. And then finally, on this introductory period, could I say that there is, of course, a useful source you'll find very valuable, a book. Mr. Levine, Jerry Levine, the author, may well be with us today, so I better watch my P's and Q's because he's a great living expert on this field. And I highly recommend his book, Domain Name Arbitration, which is now out in its second edition, and which you can buy from, I know you can buy it on Amazon, and no doubt you can buy it in other places as well. But intelligent people like you who know how to use the internet will have no trouble finding somewhere where you can buy Jerry Levine's book, Domain Name Arbitration. I highly recommend it, and it is a quite invaluable repository of a vast amount of knowledge on this field of endeavor, the arbitration of internet domain name disputes under the Uniform Domain Name Dispute Resolution Policy. Well, we can go on and to this alarming slide which you have in front of you, which is the trademark symbol, and it's there to sort of underline an importance and significance of trademarks in this field, which you will see is permeated throughout the whole dispute resolution process. You won't get very far in a claim like this under this system to retrieve a domain name which you are seeking to retrieve or obtain. You will not get very far unless you can establish that you have a trademark, and it is the very first point, I think, so far as evidence in these cases is concerned, that things must be proved on the basis of evidence. As you know, if you are chasing a domain name that your client wants or that you want, the complainant will have to prove three things. And of course, we're going to look mainly today at what these three things are. First of all, that the domain name is identical to your trademark or confusingly similar to it. Secondly, that the registrant of the domain name has no right or legitimate interest to the domain name itself. And thirdly, that it registered and has been using the domain name in bad faith. And it's often overlooked, I think, that the policy itself makes it quite clear that this is an evidence-based process. It's not enough to make allegations or to make assertions. You have to prove your case. And in fact, that's set out in the policy in somewhat bad grammar, I might say, but the policy itself says that in the administrative proceeding, the complainant must prove that each of these three elements are present. Is present, of course, because you must prove each of the three elements. And that underlines a whole notion of evidence being important and really vital to the success of a claim under the UDRP. It's equally vitally important, of course, for a registrant or a respondent, that is the party who currently holds the domain name, who is the registrant of the domain name. Because if they want to hold on to it, which most of them do in defended cases, they will take the approach that, well, the complainant's evidence did not come up to scratch. It did not prove all three, not just that it did not prove one of them, it did not prove all three, which it should. It only has to succeed on one, and it's home and hosed in its defense. So evidence is particularly important for all parties and has a considerable practical effect, which you'll see when you read. I'm sorry to say that this is one of my decisions. I've tried to avoid putting too much emphasis on decisions that I've actually made myself, because one tends to the view that they're usually right or correct decisions. So I leave that to the objective observer. But that case there concerning Daiso in Canada, where the domain name was daisocanada.com, is really particularly a good example of just how a case can fail simply because the evidence was not there. The company, Daiso Canada Company Limited, which was the complainant in this case, said, look, this defendant has registered this domain name, Daiso Canada, which is clearly based on our trademark, our Daiso Canada, our Daiso trademark, clearly based on that, and simply invokes the notion that it relates to our trademark in Canada, whereas in reality, it doesn't have much to do with us at all today. Just before going on, could I say, because I need only say it once and you will understand that the same point has been made in subsequent cases, that when I have given the name of one of your decisions, I've given the name, as you see, the file number at Cedric, so you'll have no trouble finding it on the internet because all the cases are listed there in numerical order. So you simply go to 15164 in Cedric's numbering system, and you will find, lo and behold, there is the entire decision. And that was one where the claim failed. It actually failed for lack of evidence. Daiso's argument was that, well, when this domain name was registered, it was registered in effect by our agent, that it was under an agreement under which its right to do that has now evaporated. Therefore, it has no right to hold the domain name, and therefore it should be transferred to us, Daiso, because that is our trademark. That, in a nutshell, was what their argument was. To which the defendant, this Fairchild Property Group, said, hang on a minute, things are not as simple as you are saying, because, and the panel, which was me, subsequently decided there's actually no evidence of this agreement under which it is said that the domain name had been registered. There's no evidence, apart from your assertion about it, which is not evidence, there's no evidence that there was a term in this agreement to the effect that if you broke the agreement with Daiso, that the right to have the domain name would also evaporate. There's no evidence of that agreement or what it provided or how it was to be affected. And that failure to produce evidence to that effect was the reason for Daiso's downfall in that case. There was an atmosphere around the case that there was more to this than met the eye, because the defendant said, yes, Clearly, we have registered the domain name. We understand you're not happy about it, but the fact is that there was another agreement, a completely separate one, under which we got our entitlement to register the domain name and keep it and use it for our business. And we want a fair go to explain all of that, to show how we are justified in holding on to this domain name. And there was a complete lack of evidence to the contrary. So in those circumstances, most arbitrators, I think, would have concluded, as I did, that, look, there may well be more in this than meets the eye. And when there is a defended case, when it is seriously defended, when it sounds plausible, the defense sounds plausible, it would be unwise in a summary proceeding simply to drop the guillotine on this party that has registered the domain name at this stage. It may be different in the future. It may be different if they go to court. But as things stand now, you have a case where the complainant says, oh, all this is derived from an oral agreement. There's no evidence at all of who took part or created the oral agreement. No evidence at all of what the terms were in that agreement. And in particular, no evidence to the effect that the ownership of the domain name would be affected if that agreement was brought to an end. And in those circumstances, they failed in their claim. And the point to be made here is the simple one that can really be seen to be reflected in many decisions, both from Sidgwick and elsewhere, that you really must continue to concentrate on the evidence of agreements, evidence of conduct, and any other relevant evidence to prove your case. You simply cannot make assertions or give conclusions. You have to prove it. Why? Well, because the policy says so. It says that the complainant must prove each of these three elements. And as this is clearly a civil proceeding, it means that it must be proved on the balance of probabilities. So now, having established that basic ground rule, we will proceed to look, you'll be pleased to hear in a bit more briefly than I've been so far, to each of the three elements that the complainant must prove under the UDRP, how they have tried to do that, how in some cases they have succeeded, and how in some cases they have failed. All right, now, starting at first base, the first base that a claimant claiming one of these domain names and seeking to prize it from the person who has presently registered it and who is using it, the first step in the process of claiming a domain name under this arbitration process is to prove that the domain name that you are seeking is identical to your trademark or confusingly similar to your trademark. So in other words, you must have a trademark. There is a great debate when this system was set up as to whether that really should be the touchstone or the talisman for these proceedings, and it was decided that it would be and should be, and it still is, that you must establish as a claimant that you have a trademark, either a registered trademark or a common law trademark. And I've set out there for your convenience, and you'll be able to follow them through at your own pace, a couple of decisions which have emanated from Sidgwick, which support and are consistent with the proposition that I have just made. In other words, that if you can prove a common law trademark, it doesn't matter that the trademark is not registered. Obviously, it's easier and better if you have a registered trademark, because you can simply say, well, here is our trademark. It's registered with the Canadian Trademark Authority or the Australian Trademark Authority. It is a trademark. we can prove it easily because it is registered. It's much easier to do that than to have to rely on a common law trademark, which really must be proved on evidence that a panel will accept. And that's actually a neat little collection of a few cases which show how the principles in this particular area have been followed and applied by decisions made by CIDRIC and its arbitrators over the last couple of years. I'd suggest that you browse through those. You will find that the first one, the Agrima one, is a good illustration of the proposition that if all you have is an application for a trademark that is not yet a registered trademark and therefore is not enough to support your claim, in that case, it was accepted that a common law trademark had been made out. The criteria on which that conclusion was reached is not really elaborated on in any detail in the decision, but it is a very good illustration of the fact that the prevailing view in this field is that a mere application for a registered trademark is not regarded as a trademark, mainly because it is not being subjected to examination. But that's the first point that comes from there. The other two decisions show that it's not enough simply to have a name. You cannot bring a claim under this policy simply by saying, well, I am the complainant, my name is such and such, the domain is inconsistent with my own name, therefore I should succeed and get this domain name transferred to us. It's not as simple as that. You must prove that either you have a trademark which is registered, or you are able on established criteria to show that your name or your mark is the name of your trade, and therefore you have a common law trademark which you can rely on in these proceedings. I put down a number of other decisions there which I'm not going to take time to go through them in detail, but they should be interesting for you because they show that in your own local Canadian organization, the arbitrators on that panel have now delivered a series of decisions which emphasize and underline this proposition that the standing of someone to bring a claim under the policy to retrieve a domain name, the standing is that you have a trademark which you can rely on, and a regular trademark, one which is on the register of trademarks, not just on, for example, the American Supplementary Register, and not just an application for a trademark, not just a trade name, but one which identifies you as the source of the goods and services that you are promoting in the market. So that being as it is, that is my little introduction to, I don't know why there should be 3 decisions concerning unemployed professors, but there are. The unemployed professors who write essays for students who don't really feel disposed to write them themselves will pop up a few times in our presentation. So I thought I should introduce you to the unemployed professors and then go on to say, well, what you have been saying is very interesting, but how do you prove a common law trademark? There's no register you can go to, as you can with registered trademarks, where you simply say to them, please give me a copy of your registration certificate. I want to use this in a case. That's a very simple way of proving a registered trademark. and you either prove it or you don't by what you produce on your piece of paper. If it's a common law trademark, it's a more difficult proposition, and it must be proved by evidence. In the two unemployed professors' cases that we have here, they resulted in the domain name being transferred. So they got to first base, they could establish it. If you just look at the second one, the claimant unemployed professors, as they were called, relied on the fact that they'd been 9 years in business under this name. They'd been written up in commentary websites like Slate as a global leader in this curious field of endeavor called original custom essay writing, which is a nice way of describing plagiarism, which of course they hotly deny they are engaged in. But in both of those cases, a few of these criteria were set out. Basically, to put it in my own words, if you want to establish that you have an unregistered or common law trademark, you'll have to show things like, were you recognized in the field? Did you get any press coverage? Did you hawk the name around and let everyone know that this was your name? Did you have a logo with that name on it? Can you get someone to sign an affidavit, for example, saying that they recognize that in the marketplace, this name was recognized as being your source of the goods and services that you were selling in the market? Don't be put off, as I've tried to show you there, that things get a bit messy. These are business relationships and activities which are often a bit messy around the edges, and you will find there are some complex commercial situations where you have to decide whether this was simply a name which the complainant had adopted, or whether it was actually using that name as its trademark, and whether it was recognized in the market by that name. That's what you have to prove by the sorts of pieces of evidence that I've mentioned. And it can get a bit messy, of which that Heidi Munoz and DeSantis, another one that I did actually, and I decided that this lady, Heidi Munoz, had in fact established a common law trademark in the name of her business, Myoka Reality. She had done that, first of all, because it was, after all, the name of her business, which is a good start. She was saying, I am not in business under the name Heidi Munoz. I'm in business under the name Myoka Reality. And that was a good start. There was also some evidence that suggested to me that it was genuine. In other words, there was a nice photograph of her and her children, and in Honduras where she lived, and the whole tone of her presentation was that she had been in business to support herself and her children in this reality business. She'd been double-crossed, it seemed, by the respondent who had not acted entirely properly, so it seemed. And there was a bit of an atmosphere, I think, probably skillfully created to show that it was all quite legitimate from her point of view, which I felt it was, and which I so held. I held she had, because of the way in which she had used the business name, that this was her mark of her trade in her own business. And another example there, this Kelton cases, I won't stop to go into in detail, but another illustration. So what, I don't want to, it's too early to reach conclusions about all of these cases, but I think you can see the trend that is emerging. The trend is that decisions in CIDRIC under the UDRP are starting, I think you will agree, to establish some principles widely accepted in this field of arbitration, particularly the principle that the cases will be won or lost on evidence. So we then move on to say, okay, well, now we've established the trademark, therefore the complainant who is claiming the domain name has standing in this arbitration system to make that claim, and it then has to prove all three of these three elements that I have mentioned. The first one is, of course, it must prove that the domain name that it is claiming is either identical to the complainant's trademark or confusingly similar. The confusingly similar being more difficult, of course, to establish. With respect to identical or identicality, I think you'd agree with me that something is either identical or it's not to something else. Confusingly similar is a bit more complicated. You have to show, well, this domain name and the trademark are similar. Are they confusingly similar? Would anyone be confused as to whether this domain name that is being claimed was sort of based on the trademark or trying to copy it, or might be regarded as a different version of the trademark or not? If the answer is yes, it's confusingly similar, then the complainant has established the first principle. If it's identical to the trademark, then it's an open and shut case. Confusingly similar is a bit more difficult to establish, but it can be done and is done. Is it done every day of the week? Now, to help you reach that conclusion on whether a domain name is confusingly similar to a trademark, over the years, some principles have been laid down. I think you could safely call them principles. One is that if you see the domain name in dispute contains the trademark itself, then it is presumed to be confusingly similar. I'm not at all convinced that that is right, by the way. I think the question remains, even if the trademark is there in the domain name, the basic question the arbitrator is being asked to decide is whether the domain name is confusingly similar. It may well be, of course, confusingly similar because the trademark is already in the domain name. If you look at that first one cited there, La Petition Arbeck, the trademark was Arbeck, and the trademark is in the domain name. It doesn't require a great leap of faith to, or doesn't require a great state of surprise to find that the arbitrator found, yes, a common law trademark had been established. And one of the factors clearly that you would take into account is the fact, well, look, it's almost as if there was an attempt deliberately to copy the trademark, because the person who registered the domain name put the name of the trademark in the domain name. So it's, I think I'd go as far as to say it's a good start, but it's not conclusive. The only conclusion that has to be reached is whether the element set out in the UDRP has been established by evidence and by argument. That's the point. That's what the issue is. And the fact that the trademark is in the domain name is, of course, a factor you would look at. I don't believe it necessarily follows as night follows day, that therefore the domain name is confusingly similar. The second principle that has emerged from a lot of the cases, and I've given 3 examples there. Again, we don't need to go into the details of all 3, but just to let you know they are there when you want to use them to bolster your case. I've set out 3 which come from this next principle, which is that if there's an obvious spelling mistake, which you might think is being done deliberately to trick internet users, and let's face it, it does happen that way. I mean, take the second example, if there is a trademark which is unemployed professors, which there is because I put that in capitals there, and the respondent pops up and registers the domain name unemployed professors rather than unemployed professors, that rather gives you a clue that there may be a bit of fast footwork going on here, and perhaps the person who registered the trademark, registered the domain name, perhaps the party who registered the domain name may have been minded to mislead or confuse people by changing the spelling of the trademark around. So it's pretty much established that if you find spelling mistakes or errors, deliberate or otherwise, say in a domain name you find Lesnode instead of Lesson, which is the trademark. If you find Tarsis instead of Traxis, which is the trademark, that might suggest to you that this really was an attempt to mislead people, perhaps, or confuse them. And in any case, whether it was an intention to do that or not, if you look at the domain name and you look at the trademark, and if you make the comparison which the policy requires you to do, you can, in cases like this, I think, fairly quickly come to the conclusion, yes, they're similar because they're spelt the same with the exception of a few letters, and they are confusingly similar because someone may well think, and probably would think, that finding a domain name unemployed professors, that really what they meant to convey was unemployed professors. I don't think that conclusion is very difficult to reach. Be careful about this sort of thing because, as you know, from the most recent Canadian decision, this sort of claim may fail. In that case, it's actually, I think, the most recent decision of yours. There were 3 domain names. 2 of them were clearly based on a trademark, a registered trademark. So the claimant got home on those, but the third one was not. It was not an echo of the registered trademark that there was, and therefore a common law trademark had to be proved by evidence, and in fact it was not proved by evidence. It was rejected. So be careful, it's not all open and shut. Now we move on then to the second element. Having proved our standing to bring a claim, having proved that we have a trademark, a registered trademark or a common law trademark, we have established that the domain name that is being sought is either identical to the trademark or it's confusingly similar to the trademark. Having established that, which is the first element, we can then go on to the second element, and that is that the complainant trademark owner must prove that the respondent has no rights or legitimate interests in the domain name. In other words, you had no right to register this at all and still don't. Basically, that's what it is saying. And the policy helpfully sets out some criteria, not an exhausting list or exhaustive list, but with some pointers, some criteria, which if you can establish them will show that in fact you have a right to register this domain name, you have a legitimate interest in it, and therefore the claimant trademark owner is not going to get his hands on it. And the first criteria is that, well, I've been using this domain name the respondent says, for a bona fide business I'm conducting. I'm offering goods and services to the community at large. It's bona fide. I'm not trying to copy anyone. I'm not being dishonest. I'm not misleading. I'm not targeting anyone. I'm using this in my business. Sometimes that fails, as you would see from that law petition case that I've already mentioned. The defense failed because it was being used, the domain name was being used, not for a bona fide offer of goods and services. The defendant, it was alleged and was established, was not using this in trade or business. It was being used because there was an industrial dispute taking place, and the petition referred to in the domain name law petition was a petition to boycott and do as much damage as possible to the Arbeck Forest Products Incorporated. That's why they were saying we have our domain name. It's why we are using it. It's why we populate it with arguments as to why you should buy products from another timber company, not from Arbeck. So the panelists decided, well, that's pretty clear. They were not using it for a bona fide offering of goods and services. They were using it for revenge and to destroy Arbeck Forest Products or harm them by getting people to buy their timber from somebody else. And again, the next one, another unemployed professor's one, by the way, that defense failed there because of lack of evidence. So simply saying, oh, I have a defense. I have a defense to this claim brought against me. I have a defense, which is that I have a right to this domain name because it's a bona fide offering of goods and services. Simply saying that it is so will not get you home to the last base or even to the first base. Saying that that's your conclusion is no use. You have to prove that, in fact, what you were doing was using it in your business. And an arbitrator can look at all of the history of dealings and say, well, look, I think they were using this in business in the normal course of business, and I think therefore they have a right to have registered it and used it. They're not doing anything wrong. Where that defense usually falls apart is that for better or worse, the respondent who has registered the domain name allows it to be used for advertisements on its website to sell competing goods, that is, goods that compete with the complainant. Often they say, of course, and it's understandable, it's happened to me actually, they say, well, look, these advertisements were put on the website to which this domain name resolved by the registrar whom I bought the domain name from. I didn't put them there. The general view on that argument is, well, it's your responsibility to make sure that the domain name is not used for targeting the trademark owner by advocating that people should buy goods somewhere else other than from the trademark owner. So as with all things in this field, you have to use common sense and use the best evidence that you have, either to show, if you're a complainant, that this was not a bona fide or normal offering of goods or services in the market, or really that it was completely out of your control in the fact that some advertisements were included on the website, which after all is your website and for which you are responsible. As soon as I put it in that way, you are thinking, and I know that you are thinking this, and I agree with you to some extent, that what I've said may be a bit internally inconsistent. In my defense, let me say that all cases depend on their own unique facts, and I'm simply trying to highlight this issue to, because it is an issue, and to say to you, which I do on all issues, all points arising in this presentation, don't forget the final outcome of a case is going to depend on the evidence in that case, not on the evidence in some different case. But that, I think, should introduce you to the issue. Now, you'll recall that the way that principle was expressed was that the defense is that the respondent who has the domain name at the present was using it for a bona fide offering of goods or services, or demonstrable preparations to use it for that purpose. In other words, if you can't get home on proving that you actually are using the domain name for offering goods and services for sale, you may be able to show that you made demonstrable present preparations to do that, to use the domain name for that purpose. And that will depend on simply a question of fact. It's a question of degree also. The question is, were you, the respondent, actually making preparations to use this domain name for a bona fide purpose, or do you just say that you were going to? It's no good coming along and saying, oh, well, I didn't use it for a bona fide purpose, but I was going to do so. You have to show that you did something about it, that you started the process off. You do not have to show that you had a fully fledged business up and running, but you do have to show that you were starting to make serious and real preparations at least which could be demonstrated. That's why the word demonstrable is there. Are the things that you rely on capable of being demonstrated? Well, yes, they are. Either you did them or you didn't. Things that are useful for you to say as a respondent are, well, look, I had a business plan. I got to work. I did a business plan. I actually paid someone to do a business plan for me. I registered a business name. Here is a copy of my registration of the business name. I paid for some marketing advice. I started to do some advertising. I employed some useless and expensive consultant. I employed one or two people. I paid for advice. I did all of these things, which are preparations to use the domain name for a bona fide purpose, and which are demonstrable. I can demonstrate them to you because here in evidence is a copy of my business plan. Respondents sometimes fall down on the job there, and there's some very tricky questions that arise as to whether what they claim were demonstrable preparations were in fact preparations at all, whether they were big enough or substantial enough. Say if the respondent came up and said, well, I made some demonstrable preparations. What were they? Oh, well, what they were was that I thought about registering a business name. I thought about getting some marketing advice. I didn't actually do any of this, but I thought about it. Well, that is not good enough, and that will not get anywhere. A case I had recently raised the issue of whether the respondent claimed it was making a lot of demonstrable preparations. Unfortunately, and perhaps unwisely, it had used a business consultant with whom it already had a close business relationship, and the complainant, when they put in their supplementary submission on this, said, well, that's no good at all. What's the point of saying you were making demonstrable preparations when the work you had done were done by a friend and business associate of yours? That dilutes the value of it to the extent that it is of no value whatsoever. I decided myself, because I was one of a panel of three in this strange case I had, not so long ago. I said that that's none of the complainant's business at all. If the respondent wishes to use a business consultant and pay that consultant, it is legitimate and evidence should be allowed of what was done in that regard, even although they knew them in advance or were even related to them or were partners. It doesn't matter. The question is, were they preparations to use the domain name for a bona fide purpose? And if so, were they demonstrable? Can they be demonstrated? Can they be pointed to? And if the answer is yes, then the respondent is in a much stronger position. I put a cautionary note there to the effect that when we say we need evidence of these issues, what is the best way we can do that to convince the arbitrator that we are right? Well, again, there's no point in just asserting things. To some extent, it is of limited value, I think, to have your lawyer say that you did these things. There are ways of proving issues in evidence well established over centuries, and they are, for instance, affidavit or declaration, which is the reason why I've given the whole slide over to this next alarming proposition, affidavit. It's to remind you and to remind me that you can prove things by affidavit. You can also prove things, I should say, by a much better means, and I'll just jump ahead on this to show this. What people often overlook this. Why not include in evidence a photograph? I mean, if the issue is that business was known, if the issue is that business was known as Paul Langlois Bijouterie, that photograph would seem to go some part of the way to establish that. And instead of waffling about it for a page of text, why not include a photograph? A picture tells 1,000 words, they say, and I think that is very good evidence, that photograph. If what you want to prove, which is one of the things that was at issue in that case, was there a common law trademark for Paul Langlois Bijouterie? Well, yes, there was, and it's fairly obvious. One would have thought simply walking down the street would tell you that that was the case. So why not use something as tried and tested as a photograph? And of course, the time and tested affidavit is a good way of proving things. Okay, now we move on to, we've just been looking, as you know, at the first way you can prove that you had a right to the domain name, which is you were using it for a bona fide offering of goods or services, or you could show that you were making demonstrable preparations to use it. What is the next one? And this is one of the very rare fields, I think, where there is no Canadian case yet that establishes this point, namely that the respondent says, well, this is my name. This is my own name. I am commonly known by the domain name. And this case there, which is not a Canadian one, but I'll mention it to you briefly because it's an entertaining one and it's a significant one. And it results in a photograph of me, which you will shortly see. This case establishes two propositions. The first being that you should choose your parents very wisely. Mr. A.R. Marnie, whom I'm pretty sure was a Canadian in Toronto, registered the domain name Armani.com because his parents had, of course, his surname was Armani, well, it was Marnie, M-A-N-I, and he was given two given names which started with the letters A-R. So he ran them together and said, well, my name is Armani. I am Armani. Therefore, I'm entitled to register the domain name Armani.com. And the panelists decided, yes, well, that's right. In one sense, excuse me, it is your name. And in any case, the test is, were you known? Were you commonly known? Are you commonly known as Armani? And of course, he had no shortage of people who would say yes, because everyone wanted to claim they knew Armani, and they did, because they knew Mr. A. Armani. So he won. He held on to the domain name in that case. However, if you look at where the domain name goes to these days, you'll find that it goes to this website, which is completely unauthorized, as uses the well-known photograph of me on the extreme left as part of their publicity. And that clearly is a website for Gianni Armani, Giorgio Armani, the Armani company. So obviously, when the case was over and Mr. A. Armani had won, obviously the Armani company went and bought the domain name from him, no doubt for some substantial sum. And he's presumably sunning himself on the beach in Acapulco at the moment on the proceeds. But the point that emerges is that he was able to hold on to the domain name because he was commonly known by that name. So now the third way, the third criteria, you can show that the domain name was being used for legitimate non-commercial or fair use. And this is the area where a lot of cases like fan sites, tribute sites, gripe sites, political speech, dictionary words, acronyms, things of that sort, you can, subject to the evidence, like everything else, it's all subject to the evidence and the arguments you put forward, but you may be able as a respondent to succeed by showing that, I was not using this domain name to make money. I was using it for legitimate, non-commercial or fair use because it's a dictionary word, a generic word. I was engaging in political speech, which is guaranteed under the United States Constitution and generally accepted in international law. It was a fan site. I have a fetish about this celebrity or that celebrity. I was not making money out of it. I was simply promoting the site because the domain name reflected a celebrity or actor or author or painter's name whom I adulate. And that's my defense for having and keeping, thank you very much, this domain name. Well, yes, that can be done and is done, and it's a very legitimate defense. I have made decisions myself which have implemented that. Be careful, like all defenses, it will not necessarily succeed simply because you say it's your defense. It failed, in fact, in this Arbeck Forest Products case, as the purpose or aim of the domain name and the petition that in question, which is a notion embodied in the terms of the domain name itself. The aim was not to promote the interests of the Big Forest Products Company and show how nice they were or what good products they made. The aim was to injure them, to do damage to them during this industrial dispute by way of a boycott. And the arbitrator found, quite correctly in my view, well, you were not using the domain name for legitimate non-commercial or fair use. You were using it in effect to line your own pocket and to win this financial come business come industrial nations dispute that you had with the trademark owner. Likewise, it failed here in this other case concerning a firm of lawyers, Levy Zavet, where the lawyers got a domain name together and wrote to lots of people and said, we've found this very big unclaimed estate, millions of dollars involved, and we noticed that your name is the same as the name given to a beneficiary of the estate, which we cannot find. A bit like offering the public, I'll leave it to your imagination to think of some analogy. But that failed there because it was not being, the domain name was not being used to promote the name Levy Zavet, which was a well-known firm of lawyers. It was being done to perpetrate a fraud and to invite people to become participants in the fraud of making a claim on a deceased estate, which they knew and which the party encouraging them to take part in it also knew. Everyone knew that this was something they were not entitled to. So that is that one there, and that is another criteria that can be used. I just want to touch on this and say there's a lot written about this. I mentioned generic words, and it's here where a lot of debate takes place as to the proper credence to be given to a generic word in a domain name or an acronym or a dictionary word. And the disposition these days, insofar as you can sum it up accurately, is yes, subject to the evidence and subject to the registrant of the domain name not using it for any improper purpose, sometimes referred to as targeting. But subject to that, yes, that defense can succeed, and you can show and claim that, well, this was legitimate because it was an exercise in free speech, perhaps, or because it was a generic word over which, despite what the complainant says, it does not have a right against the whole world to stop anyone else from using the word. It's the classic case, I suppose, of a case and the outcome of a case depending on the evidence that is adduced. This one was a strong case because the respondent was able to show that it had not been, or it emerged on the evidence, I should say, that the respondent who registered the domain name was not using it to target or do any harm to the trademark owner. It was simply to promote the name itself. In any case, the case was doomed for other factors, which you see there. And in fact, it was so bad, so weak a claim that a finding of perverse domain hijacking was made against the complainant. In other words, the case was so weak and so bad that the complainant should have known that it was going to fail and should not have filed the complaint, but did. Therefore, our disapproval of what it has done should be marked by a finding of reverse domain name hijacking, which very briefly is a right that arbitrators have under the policy. It doesn't carry a financial penalty, but it is not a desirable black mark to have registered against you, namely that you knew this case would fail. You even knew it at the time when you were implementing Plan A, which was to buy the domain name before you started to claim that it was actually yours. You tried to buy it from the registrant and you failed. Then you moved to Plan B to intimidate the registrant of the domain name. So I think that's enough on that. I simply want to alert you to the fact that it is an issue. It's a very live issue. It comes up in many cases. You have to be careful that even though you're using a generic word or an acronym in the domain name, you have to make sure that you're not giving the whole game away by using it to criticize or attack the trademark owner, or to double cross it, or engage in any activity which might be deleterious to it. So we've now covered cases that have been arbitrated here at Sidric on the first two issues, and now we come to the third, which is an area, of course, often where cases fall down, namely that the domain name was registered in bad faith and that it has been used in bad faith. You don't need me to tell you that both must be proved. It is not the case under all systems for the arbitration of domain name disputes. For instance, it's not the case under the Australian system, nor is it the case under .eu, the Europeans' revenge for .com, as I put it sometimes. But you still, under the UDRP, the complainant must prove that the domain name was registered in bad faith and used in bad faith. And again, the policy itself has been helpful in giving some criteria. So if the complainant can prove any one of these criteria, it will have proved that the domain name was registered and used in bad faith and will be successful in the case. You'll notice the way the terminology has changed. Under the right and legitimate interest to a domain name, and the complainant trademark owner must show that the registrant has neither a right to the domain name or a legitimate interest in it. The way in which that is done, the terminology, you will recall, was expressed so that if the respondent, the registrant, could show any one of these criteria, then it will have succeeded. It's very different when one comes to bad faith. Here, the complainant must prove at least one of these tests. If it can show resale, if it can show any of the other criteria, then the rules say, the policy says that that is evidence of registration and use in bad faith. I won't go into the detail. There's some fish hooks in that proposition, which we can pursue another day, but you'll notice the way in which the terminology has changed. So now what we are doing is looking at whether the complainant can prove any one of the specific criteria that the policy sets out. So the first of them is, does it appear from the evidence that the domain name was registered with the intention of reselling it to the complainant, in other words, to encourage them to pay a high price for it? And the first one is one of your cases. It's a good case with a decision very worthwhile reading. And given fairly recently, this is the Bijouterie Longois one again, where it was very clear that the purpose of the domain name had been to extort money from the trademark owner, and therefore it could be said, well, the intention must have been from the word go, when it's so obvious that they were trying to extort money from the trademark owner. It's quite obvious that from the beginning, this was the reason why the domain name was registered in the first place, with the intention of doing this, with the intention of, in effect, forcing the trademark owner to buy the domain name. I emphasize again, and I hope I'm not becoming too tedious about it, that the conclusion that will be reached on this, whether the intention was to resell or re-let the domain name to the trademark owner or a competitor, That is a question of facts, and it will depend on the evidence given. But the principle is there, the rule is there, and it's a question of whether in the case that you are handling, either for a complainant or a respondent, that the evidence either proves that proposition or it disproves it. All right. Secondly, the intention may have been to prevent the trademark being used in a domain name, and there's one illustration of that, which is certainly, I don't want to take time by going over it at the moment, but that is there, you've got a decision on that. You also have a good decision on the next criteria for bad faith, which is disrupting the trademark owner's business. And it was held clearly in this case, yes, this is what was happening. The intention of the person who registered the domain name was to disrupt the business of the trademark owner. Because you, the party who registered the domain name, was in fact a former agent of the company, you had been terminated, you kept the domain name, you refused to hand it over, you were using the trademark owner's trademark, and specifically you were preventing it, the trademark owner and complainant in this case, from using a domain name, particularly in its Charleston business, which it wanted to do. The domain name you were allowed to register with Sunspace, which is the trademark of Charleston. So that means we can't have a domain name which you can use when we are, now that we've got rid of you, we want to appoint a new agent in Charleston, and we can hardly give him a domain name when you're sitting on it. Therefore, you're preventing the complainant from using the domain name for its Charleston business. And that was the argument that carried the day in that case. It was, in fact, a form of passing off that the person who had registered the domain name, although he had been sacked as the agent of Sunspace in Charleston, was still using it. He was using their trademark. He was using the domain name. He was claiming that he was Sunspace's agent in Charleston by persisting by using the domain name. And the arbitrator decided, well, all of that amounts to disrupting the trademark owner's business, which is bad faith, and therefore you're going to lose this domain name, and we hereby transfer it. It's the same in the other case that we've already looked at twice, the Arbeck Forest Products case. Another one of yours is the Husky Oil Operations case, where what the respondent was doing with the domain name was phishing, trying to get personal contact information from members of the public. It's a tried and regrettably a tried and tested method of acting improperly and for clear, obviously, monetary reasons. Go phishing, provided you spell it correctly, and try and get a lot of records and contact information from people. Redirecting them, you'd really wonder why people do this, but they do redirect the domain name to the complainant's own site, obviously to build up a record of dealings with the company so that some improper conduct can then be embarked upon. It may not always be that, and again, I emphasize, without wishing to bore you, that it all depends on the facts of the individual case. All right, and the big one, finally, the big one, this is the big one which establishes bad faith, namely, were you sowing confusion in the market? Employment scams are an obvious one, which I've given some examples of. I maintain that bad faith is something that you know when you come across it, and if it comes about because you are trying to confuse people in the market, you'll know that is bad faith because it's self-evident. Again, I don't want to cite too many decisions which are non-Canadian decisions, because this is a Canada Day today, but there is a non-Canada decision which will remind some of you who spent reckless use playing Legend of Zelda. Nintendo, who had and has the Legend of Zelda internet gaming game, forgot to register the domain name Legend of Zelda, which was done by a young man who was an aficionado of the game. And Nintendo, of course, got up in arms about this and moved heaven and earth to prize this domain name from him, which they failed to do because the arbitrator quite rightly held, look, this is not bad faith, this is good faith. What this young man was doing was promoting Legend of Zelda as a good thing, developing storylines, promoting gossip about the characters. He was a really fetish-oriented Legend of Zelda fan. He was actually responsible for Nintendo making a lot of money, because after he set this website up, Nintendo started to sell more copies of the game. So it was actually good faith, not bad faith. But you will know bad faith when you come across it. And there are some decisions which have already found their way onto the record at Sidric, showing what bad faith is. The employment scam is a popular one, regrettably, which is still in wide use. Having looked at cases in Cedric from the issues arising on these three essential elements that have to be proved in any case, let me just now end with a sort of, I was going to say ragbag, a sort of collection of issues which have been touched on in decisions through Cedric, which shows that it's on the ball, that the arbitrators appreciate these points. They are writing good decisions because they are attuned to these issues and making decisions precisely on these issues. They are a random collection of various issues that come up, and you'll be pleased, I hope, to hear me say, well, there is there's a case in Cedric on this, which is right in point, and it's good to know that arbitrators through Cedric are in fact writing decisions, and they're being published and no doubt acted on, which touch on these significant issues. In view of the time which is moving on very rapidly, as time does, I will do this fairly briefly because I want to leave at least some opportunity for you to ask questions, which I hope I'll be able to answer. So let me go through them. One issue on which there's at least one decision on the language of the proceedings. This arises as an issue surprisingly frequently, because you have, when people buy domain names from, particularly from some overseas registrars, the language will be in a language which is not, the language you're familiar with. So the question is, what language will the proceedings be conducted in? And the policy provides that the proceedings are to be conducted in the language of the registration agreement under which you bought and hold the domain name, unless the panel decides on good evidence that it should be a different language, usually English. And that first decision touches on that, and I would recommend that you keep that in your bottom drawer or up your sleeve to have a look at in due course to see the way that issue was resolved. It is also, I think, it's the only decision I know of where this language issue becomes one where what happens if you have actually two languages? The domain name is in one, but the trademark is in another, in this case, Russian. It was a Russian trademark. And the proposition was made in the decision, which seems to me fairly sensible, that when you are determining confusing similarity, when the domain name and the trademark are in different languages, you take the meaning understood by, and the rest of those words, which may not be the most felicitous choice of words, but I think what the panelist was trying to get at was you take the meaning that is understood by a considerable part of the public who are likely to be looking at where the domain name is used. And if they would find it confusingly similar, it doesn't matter that the trademark is in a different language from the domain name. The other issue, which was again an oddity, is that, and useful as a decision to have, is the panelists made the point that it doesn't matter if the change made to the trademark for confusingly similar purposes reverses the order of some words. If you can still say, despite the fact that you put author 24 instead of 24 author, or 24 author instead of author 24, depending on what the trademark is, that is not fatal to proving confusing similarity. You could still prove it if the objective observer of the domain name and the trademarker would reach the conclusion, well, this domain name is confusingly similar to that trademark. It doesn't matter either if they're different languages or if words have, the order of words has been reversed. So for someone who said he was going to do this quickly and promptly, that took a bit of time to say, and I must apologize for that. You have at least one decision allowing consolidation of different disputes, which can be done discretionarily under the rules. A third issue where there is at least one decision is this issue which comes up frequently in defended cases, in almost all defended cases, where one party wants to either to patch up its case or to answer objections raised by the other side. Can you put in a second supplementary submission? Answer, yes, you can, but it's up to the panel to decide whether to accept the additional submission. The general view is that you have to show not that you forgot to put these points in your first submission, but that there are exceptional circumstances. I decided one the other day where I knocked back, I think, 5 of the matters they had included in the 6 matters in their supplementary submission. The one I let through, I said, yes, we should have a supplementary. We may have a supplementary submission on this particular issue, which was, this was the first time that the complainant had discovered that the respondent would be asking for a finding a reverse domain name hijacking. That's the first the complainant would have heard of that, and therefore I thought on general principle they should have the right to reply to that. And so I said yes, as one of the panel of 3, I should say, and my view was not reflected by the other 2 panelists, but I thought that one should. The other panelists, by the way, did not want to knock back all of the other issues. The other 2 panelists wanted to allow everyone to put in anything that they wanted. Well, I decided that was too wide. If you do that, you may as well have court proceedings. The policy and the rules are quite clear. This is a simplified process which should work with one submission from each side. And I therefore said I would not allow a supplementary submission by the complainant on a whole series of other matters when they, in some cases, must have known, if they had their wits about them, that this would have become an issue in the case, and they should have put the evidence in their first submission. Anyway, that's where that stands. You have one decision on the evidence that may be adduced in a supplementary submission. Fourthly, under the heading all is not lost, because people think it all is lost if they have lost a domain name because they forgot to renew it or it was hijacked. That is not the end of the world. All is not lost. And if you find that's been done, as in the Angel Sensor case, where what the respondent had done was copy the complainant's website and imitated the complainant, then that's the sort of ground which you should pursue. You can still succeed in a case. All is not lost if you have some evidence that will support your case, even although you forgot to register, to renew the registration of the domain name. It's a very irritating thing from which I've suffered myself, actually, when you or someone overlooks re-registering a domain name, and you either have to buy the name from some scallywag who's already taken it up and using it for a different purpose, or you have to get around it somehow or other. So all is not lost. Fifthly, may a panelist, an arbitrator, do limited private research, such as looking up the Wayback Machine on archive.com, which is a fund of interesting information. Yes, a panelist may do limited private research. To some extent, I may be right or wrong. I'm not sure about it. I probably go a bit further than some others by allowing this private research. In these circumstances, if the, say, complainant, for instance, says, we are a well-known and successful company, and our website address is so-and-so and so-and-so. In my view, that is then in evidence, and the contents of their website is itself in evidence. And if you can find by reading 500 pages of their company background something which would advantage the respondent, say if the respondent is undertaking this exercise, then because the complainant has put their website in evidence, the respondent is entitled to use it. Vice versa, it's not a policy or principle which is there for benefiting one side or the other. It's there because it will help the arbitrator get to the bottom of the way this dispute should be resolved. Sixthly, and again very briefly, you must remind yourself that the UDRP is not a dispute resolution process for all general commercial disputes. It's for resolving domain name disputes. I have many times said in a case, well, we actually don't have jurisdiction over this dispute because the dispute is a general commercial dispute which concerns a domain name only in the most peripheral roundabout way. It's not really a domain name case, and therefore we're not going to, we don't have jurisdiction over this. The other, and they are separate, the other ground for declining to hear a case because it's a general commercial dispute is where it may be a domain name case, but it is clearly very complicated by trust deeds, conflicts in the oral evidence, exaggeration, and all the rest of it, where you really have to say, look, a panel which is deciding these things on the papers does not have the forensic tools to reach a rational and correct decision because the thing is so complicated. This really should be in a court so you can have discovery and interrogatories and perhaps a hearing with witnesses who can be cross-examined. It's the only way you will ever get to the bottom of the issues involved in this case. So on either of those two bases, there may be a circumstance where it is not appropriate for a UDRP panel to purport to arbitrate on the dispute, not appropriate at all. And as I say, in some cases, you could say it does not even have jurisdiction to do that. My purpose in mentioning it here is simply that there is at least one case you have had emanating from Cedric, which illustrates that proposition that the UDRP is not to be used for general commercial disputes. Seventhly, and finally, reverse domain name hijacking. Has it been found in Cedric cases? Yes, it has. Has it not been found in Cedric cases? Yes, it has not been found. So there is one case each way. You can see what influenced the arbitrator in finding in the Clear platform case, yes, this conduct of the complainant was so bad that there should be a finding of reverse domain name hijacking against it. And what influenced the arbitrator to decide the opposite in the Agrima and Kapongo case to reach the conclusion, no, this is not appropriate. The elephant in the room when you're deciding issues of reverse domain hijacking, of course, is this the finding of RDN H, is it of any value? It doesn't have any penalty attached to it. There's no, it's not like an award of costs made against an unsuccessful plaintiff. No, none of that at all. But it is a finding that the complainant, and by implication, its advisors, should not have brought this case at all. They knew they would lose, and they were using it as a tactic to intimidate and harass the domain name registrant, which you should not do. So there is at least, there are two cases on reverse domain name hijacking. Finally, may I say that the message I would like to leave with you is simply that this word prove, which is in the policy, is very important. And you prove things by evidence. That's how you prove them, not by asserting them, not by arguing about them. You prove them by evidence. All cases depend on the facts, no matter what the law is. So remember, they are the two things, I think. And also, for purposes of today, of course, may I also say that it is very good that Cedric can produce a whole series of decided cases now, which illustrate all of those points that I've been covering for far too long in time, and I apologize for doing that. I will therefore stop and express the hope that Cedric continues with its good work of producing viable, sensible, I think correct decisions by a panel of obviously competent arbitrators. I would urge people, particularly in Canada, to use the Canadian Centre, Cedric. You will find that they do a highly professional job under the watchful eye of Ina Anasiga, who runs a strict shop there and does a very good job together with her colleagues. I'm not singling anyone out, of course, for a singling out purpose. The whole team works very well. They've had 2 years of producing good decisions. May they now go on for many more years, producing more decisions. And if you have any questions and you want a curbside opinion of what I think about anything, do drop me an email or ask one of the other well-known practitioners in this field, and they will be only too happy to help you. Thank you very much indeed. And if there are any questions, I'll do my best to answer them. If I can't answer them, I'll probably ask Jerry Levine to step in, he being the source of a lot of knowledge embodied in his book. But we'll see how we go. If there are questions, please feel free.
Thanks, Neil. There was a question that came in through the chat quite a while ago.
Yeah,
when we were on a different topic, and I forget exactly what the topic was, but the question was, why isn't that considered comment or criticism? And I'm sorry, I now forget what the context was, but maybe, does that jar your memory what you might have been speaking about at that time?
Not immediately, no. If I made any criticism myself, it would have been that I hoped that things would. I'm just going to try and adjust my screen here. I've lost the slides.
Oh, we have a further comment to clarify. It was the Lapetition Arbeck case.
Yes, sure. Well, the point was being made. Yes, I know. I understand the question. The question, by the way, is this. The question is, when I was speaking, I made the point that this was probably not a legitimate use of a domain name because it was being used in an industrial dispute. I think the questioner is now saying, yes, that's all very well, but it surely was criticism. There can be arguments about industrial disputes and merits on both sides of the issue. So isn't it consistent with this lofty notion of freedom of speech that you speak about, that everyone should have the right to an exchange of views? And I tend to that view. What I was trying to do, I think, was to say there is a decision there of yours, Cedric, a decision that emanated from an arbitrator under Cedric, which says there has to be some restraint on the way in which you use a domain name. I think that's true, but I'm all in favor of, if in doubt, my view would be, probably in sympathy with the questioner, my view would be to lean in favor of free speech and a free exchange of ideas and arguments, even if it was in the context of an industrial dispute. But I was simply saying, here is a decision that illustrates this point, and you probably should have regard to it when you're acting, as some of you will, for complainants, and also when you're acting, as some of you will, for respondents. Simple as that.
Thank you.
But anyway,
does anybody else out there, if you're still with us, have any questions?
If anyone wanted to pursue that issue, and it is a big issue, it's a big issue. Probably, I think, the biggest issue, partly because a lot of people, and I think urged on by WIPO, to be perfectly honest about it, are tending in the other direction of getting some sort of monopoly, I fear, on ordinary words and issues and debate in the community as a whole. I'm in favor of a free exchange of ideas and debate on any issue, anywhere, at any time, provided that can be done responsibly. But you may want to pursue that in an email. Okay, anything else?
I know we've gone a bit over time, so maybe
we have gone over time, and I must apologize for that. But let me just reiterate, if you can reiterate something for the third time, that it's quite a collegiate atmosphere in this arbitration of domain name disputes. So I hope no one will hesitate in sending to me or anyone else a question or an issue that you would like to promote. The more a free exchange of ideas, the better. So don't hesitate in writing to me or one of the other practitioners on any issue that concerns you.
Well, Neil, that brings up a good point. You said any other practitioners. I'd like to let our audience, our remaining audience, know that we have a new feature on our website where we have listed a roster of counsel that are practicing in this area of domain name disputes.
Oh, good.
If you go to ciidrc.org, you click on our menu, which is in the top right corner, that will take you to a drop-down menu. And in the right-hand corner of that drop-down menu, it says Experts Corner. And right at the bottom, you'll see Directory of IP Lawyers. So there's a chance here for you to, if you're looking for counsel or to talk to someone, you can find a list of people that do practice in this area. And if you practice in this area and are interested in becoming listed on the ciidrc.org website as a practitioner in this area, please let us know. You can apply to be added to our roster of IP lawyers practicing in this area.
And I can verify, Barry, that you are a witness of truth, because I've just done what you invited, namely to see what comes up on the website. And lo and behold, it does exactly as you have said. Directory of Canadian IP lawyers. What a valuable service that is. So you are absolutely right. It is there, and we hope people will follow it up. Okay. Barry, thank you very much for your hospitality. I hope that's okay.
Yes, thank you very much, Neil. That was a very thorough and interesting discussion. And I hope that everybody that attended found it valuable. I know we've seen some positive comments already coming into the chat feature. I should have told you at the outset, if you had questions, to send in a chat. And there's also, as of course, the Q&A feature, but I think people figured that out on their own. They're familiar enough at this stage of the pandemic about how to use these platforms to.
They've learned the hard way.
So take care, everyone, and Neil, have a good rest of your Friday.
Thank you very much, Barry, and to Ina and to the rest of your Cedric family.
Thank you very much.